I was wondering, when you were talking about sovereignty earlier, what would be the ideal for you?
In terms of sovereignty, what would be the ideal? I'm going to answer that in terms of what I think would be the ideal treaty process for negotiation. So, first of all, before you, as SICOM, before you go to the table, you'd have to have a discussion amongst your own people and be really clear and comprehensive of who you are as a people, who your people are, a definitive list of citizenship, what your territory is, what your worldview is, organized in 2016. I believe you need to take your ancient oral traditions and put it into a written constitution. That gives you your baseline, that gives you your mandate, that gives you your negotiating parameters. And then from there, before you get to the table, you need to determine and let's remember, treaty making and these negotiations are really about, when you boil it right down, they're about power. They're about who wields power over what. You need to decide which powers must you, if any, must you maintain, what must you retain to maintain, to protect your identity as a nation. And ideally, it's probably not ideal, but in today's world, you look at Canada's constitution, every power that Canadians contemplate is listed under section 91 and 92. That's the numbers, right, Robert? Those are the whole list of powers that are divided between the federal crown and the provincial crowns. You need to look at, or maybe there's some that they haven't contemplated that your nation needs. Maybe there's some cultural ones or intellectual. But you need to decide amongst those which ones you're going to absolutely need to maintain for yourself. And I think if you're going to the negotiating table, you've already decided that you're going to share and coexist with the Canadians. If you were just asking them to leave and jump on their ships and go back where they came from, you wouldn't need a negotiating table to do that. You'd probably need an army. So, you're going to be contemplating sharing some jurisdiction, some powers. You need to be clear to yourself which ones you're willing to share. And maybe you need to decide which ones you're willing to give up. Because when you go to the negotiating table, they're going to be saying, the power over foreign affairs? Don't be ridiculous. You can't have that. You decide whether you want that or not. But, you go to the table, they act like it's a foregone conclusion. All those things. One thing I noticed is when, through the BC treaty process, we pushed Canada to come to the table on governance powers. Before they just do land and do governance separately. And they came, but when they came with a really good policy. They recognized 3 orders of government, federal, provincial, First Nation. They seemed to have a long list of powers that they were willing to negotiate with First Nations. But on closer look, all the powers that they were willing to negotiate were provincial powers. They weren't willing to discuss any of the federal ones. But anyway, to me, that's ideally in a negotiation how you'd go about it. And every power, you protect the ones you need. Most of us would, need jurisdiction, lawmaking authority over lands and waters and resources. Most of us want jurisdiction over our governance institutions, over our culture. We got to be clear about which ones we're not willing to give up. And then we got to be clear about which ones we're willing to share and be clear if we're willing to give any up. That's an ideal negotiation to me around nationhood.
I'd just like to add a comment to that also. is that I think, I mean, what you asked is a very, very important question, and I think that it's a very fundamental question for us, because as First Nations people, we've allowed ourselves, and we've tied ourselves up in this whole question of sovereignty. You know, that it was all or nothing, and it ended up that sovereignty really almost doesn't have meaning anymore, because we have tied it up in so many different ways, when really it is making that declaration of who you are, where your land is, and how you govern yourself. You know, it's not this this sort of concept of that when you do that you're selling out, or you're giving away sovereignty. You know what I mean? Like we've created such a confusion in our own minds around that. And I think that we've just expended too much energy on that, where we should be having the energy in determining for ourselves what we mean by sovereignty. You know, never mind what other people mean by it, including other First Nations. Because it's like we were talking about yesterday, where a lot of the fighting that's going on now is amongst First Nations against each other. You know, that we spend a lot of time demanding others recognize our sovereignty, but we refuse to recognize our nation, our neighboring nation's sovereignty also.
What can I say? Not very much. But I just wanted to say that from the perspective of being sovereign and the articulation of what you view as being a sovereign people, from a practical perspective, in the Yukon, we basically said the definition of sovereignty is unique to every First Nation, to every tribe. They can define that. What we're talking about in the treaty-making process is not a denial or an extinguishment of that inherent right. And so instead, we just looked at a practical means to relate to the other asserted sovereignty within Canada. And so we wanted a construct that we felt was practical.
Thank you. We have another question over here from Kitsilas.
Well, my name's not Kitsilas, it's Clarissa. No, my name's Clarissa Spencer. I'm from Kitsilas, as Angela says. Thank you for everything. Thank you for your presentations. Everything is, it's such a wealth of knowledge here, and I'm just very fortunate to be part of this forum. My question is, what would be, to each of you, what would be one concept that you would use to persuade a person who does not believe in treaties, to convince them that it is the right way to go?
Do you want to start with Dave this time, or who's?
I think that how you persuade people to adopt your perspective of treaty making, or the need for it, again speaks to a reflection of their culture, a reflection of their language, and a mechanism to exercise lawmaking in a fashion that would make sense. And that their participation within a treaty is not an extinguishment of their right to be a citizen. And that at the end of the day, when they ratify your treaty agreement, if they are still opposed, they still could vote no to the question that is put to them. That is their choice. And from our experience, to use enticements like promises of per capita checks that may be received in the mail as either ongoing payments through resource royalty sharing are not any sort of contemplation of enticements that we consider to have been appropriate. We just basically say, here's the land, here's the money, here's the power, and here's the construct of how they all interrelate, and it's your choice to decide if it's acceptable to you or not.
That particular question, of course, is so much a part of all of the discussions that you're involved in now, and I think that quite often the reason that we get into those situations is because there has not been enough dialogue, definitely, amongst the parties, and that you really do need to be able to have that kind of what we were talking yesterday about citizen engagement. And I think that what we don't do well enough, the ones that are working very hard toward reaching something, a better life for our people through treaty, is that we don't challenge enough those who say treaty's not the right way. So if treaty isn't right, then what is? Tell us. Talk to the people about what should be going on. If it's not treaty negotiations, if it's not reaching, a settlement that is going to be better for your people, that gets you out of the Indian Act, what is it? And let's together as a people, if that's what all the people want, that you've, that's identified as your nation, then perhaps that is, you need to go in a different direction from these particular treaty negotiations. But what I found is that when challenged with that question, there is no answer. We've worked very, very hard for a long time, for at least one generation going into the second, on finding an answer here for us here in British Columbia. And we haven't yet come up with something else. Because right now it's people, they don't want the status quo. Well, yeah, that's why we're in treaty negotiations. And then it's like, well, that's become the status quo. All we're doing is negotiate, it never gets anywhere. And so they're opposed to it. But then what is the option? And how do we get there? How do we work together to make that option work?
That is a really common question in the circles I travel in about anti-treaty or not having any use for the treaty negotiation option. I find it's mostly amongst people who don't think enough, people who haven't understood what the issue is we're addressing and what the options are to realistically address them, as Sophie says. We got to understand that treaty is an international term. A treaty is a formal agreement between sovereigns who recognize each other. It's between nations. And the content of a treaty negotiation is primarily about jurisdiction. That's what a treaty is. A treaty isn't about program delivery. A treaty isn't about being subservient in every sense to another sovereign, to another government. It's about sharing arrangements for power. That's what it is in the nation states of Europe and Asia, and that's what it is here in British Columbia when we're talking about treaties between Canada, British Columbia, and First Nations. Now, having accepted that, and I believe that's a fact, that isn't even something you debate. Now, how do you achieve that? You can wish away the other party, hope they go away. Remember, this is the power arrangement, if you wanted to do a graphic of it. Our people were here first, and our title is embedded in the earth, on the ground. Plopped 100% on top of it is the Crown's title. That's suffocating us. We've got to figure out a way of having our title surface alongside theirs to make a whole. That's the notion of treaty making. If you want to just sit back and take it and wish they're going to go away, it probably ain't going to happen. You're going to have to engage in a real power sharing negotiation. And you know what? You only have one currency in that negotiation. The courts, we have Ian Binney here from the past Supreme Court of Canada judge, and Justice Slade, who was here. The courts can only do so much in that regard. You know, the courts don't have their own sovereignty, but the courts can recognize what Canadian law establishes us and give us tools to empower. The more that we've been pushed down, to empower us to stand on our title, our rights, and turn those into mutually recognized jurisdictions. The only forum to do that is a treaty forum. And one thing Harry Slade said earlier, if we wait for the courts to do it, I don't think they're going to do it in 130 years. They're probably not going to do it in 500 years. At some point, you got to sit down and face reality and deal with it. And here, I wasn't going to make a speech. No, I want to say this. My people, the Haida people, have decided that we're not giving up 1 inch of Haida Gwaii. No Haida leader will ever have the mandate to give up 1 inch of our homelands. We'll share generously, but we are not giving up ownership and jurisdiction. Now, others have said, and for practical reasons or for whatever their cultural reasons, however they see it, they have a comfortable way of coexisting with those other powers in arrangements that are closer to their mandates. Quit looking at me so hard, Dave. But you know what I'm saying, that there's different ways of doing it. And we're going to have to be patient. As hard as Canada isn't going to come running to the table right away. But we do have joint decision-making agreements over 100% of our lands. We're working on the oceans now. It's going to take time to deal with the power question, the jurisdiction question. We're willing to spend that time. It doesn't mean everybody should do that, because we're all very connected here as First Nations, and one nation's success is going to benefit all of us, I think. And I know we're all going to end up in the same place. It's kind of a bumpy road getting there, but good question.
Thank you very much. I wonder, I'm not seeing any questions right now, so maybe I'll ask one. We know that there's been a lot of challenges in the treaty process in the last few years, and I'm wondering from all of you, with your respective experience, if you have some suggestions about how we might strategize to break through on some of those challenges that we've been faced with at the tables.
I think Robert Morales should answer that question. He's been coordinating the Common Table, who have done excellent work. And when we look at fixing this process, and I think right now the BC Treaty Commission is well positioned. I wouldn't want to. Anyway, I'm going to. BC Treaty Commission would do really well to put in the Canada and BC's attention very directly their commitments that they made 22 years ago to this process that they are not even close to living up to. Is Mike Harcourt still here? I want him to say that. But they're not, they're not even close to living up to that. And I think Canadians should be aware of that, and we should bring it back in line so that we can create conditions for more treaties in this province. And the Common Table Working Group, I think, has done excellent work in that regard and laying out options for how to do that.
And following up with that, both the federal and provincial governments were required to create legislation within their systems that brought about the Treaty Commission. And I think that we don't maybe have, or we haven't pushed that enough, that they have their own requirements, their own legal requirements. Like, I really don't know how BC can get away with not fulfilling their own legislation in terms of the commission by continuing to strip the tables of negotiators, strip all the resources away, because they have this piece of legislation. I think we maybe need to be looking at using the laws of BC and Canada and making them live up to their own laws.
I've got 3 thoughts as to how to improve the process. One is the fact that the Crown in Right of Canada has the exclusive authority to make treaties. And it's obvious that BC is sort of an impediment to treaty making. That's my impression as an outsider. And so if the Crown and Aboriginal people agree to work out a treaty, historically, that's the deal. Now, I recognize that there are issues with respect to the non-involvement of BC, but their role in treaty making should not be, with all due respect to those from the province that may be in the room, is not to be the impediment to the process. The agreement is with the Crown. So that's one thought. Second thought is I agree with Miles on the thought that there has to be a common constitutional backbone in the province of BC that all First Nations could agree on. What is that construct? And I think it's too much to expect that there be 40 separate treaty tables that have separate constitutional constructs. And if you can all agree on basic principles like certainty, like land tenure perhaps, like development assessment processes, environmental assessment processes, I think that would certainly facilitate and give you a good common background. So there's no disparity and there's no unfairness within the process. Thirdly, I think that there should be accessing to more resource sharing in the province of BC. Currently, I think you're all being funded by loan agreements, and those loans become due. Our process over 20 years cost us $100 million at 8%. We've paid all of that down, and but now we currently have in the Yukon, in terms of resource sharing, about 25% of all Crown royalties in the Yukon Territory. Now, had we had access through the 20-year treaty-making process, we would not have gone into that debt. And I think if you can access some resources during the interim period without encumbering your citizens with the resultant costs of the treaty-making process, that would buy so much good faith amongst the parties, and that's a tool that I think the parties could contemplate as well.
I was just saying that doesn't have to compromise anyone's sovereignty. That's probably pretty close to reality in this province. You know, I know on the North Coast, and Joycelyn and others who are from the North Coast, we have a lot in common in our governing systems and how we assert jurisdictions. You know, there's regional frameworks that we could benefit from in working together and still be who we are, still implement them in agreements in our own way.
Thank you. How serious should we as First Nations take Mr. Trudeau when he says he's going to implement the United Declaration on Rights of Indigenous Peoples?
I think it's in our interest to take him at his word, that he's serious about implementing the UN Declaration on the Rights of Indigenous People, that he's serious about establishing a mutually respectful nation-to-nation relationship, and I think we should stand up and meet him at the table as nations. A lot of us have work to do before we can do that with strength. And that's just the reality, and we need to pull that together, I think, fairly quickly. And the work that the Treaty Commission has been doing, and I think we need to help each other. You know, you read the reports from last year's session. Regionally, provincially, we can help each other on strengthening that definition. But I think we should take him at his word and meet him at that nation-to-nation table and be clear about what we want, what we see as an acceptable relationship.
Do you want to add? Yeah. Don't think there's anything more to add to that. I totally agree. I think that we have an opportunity here, and it's really up to us whether or not we're going to let this opportunity go by, as we have let other opportunities go by. You know, we had, a few years ago, we had the opportunity of the R&R with the province. Recognition, reconciliation. That was an opportunity that we let slip through our fingers. We did it to ourselves. We can't afford to do it again.
Let me just underline this by this, just tell you a little story. In 2004, I resigned from being Chief Commissioner of the Treaty Commission to run federally with Paul Martin, because he told me he supported the BC Claims Task Force report. He wanted to implement an honorable nation-to-nation negotiation. So the thought of running, my mind gets carried away. I was imagining me standing up as a front bench minister in the House of Commons, facing down the forces of evil on fighting Indians with the Prime Minister and the governing caucus at my side. But I had to get elected, and I didn't. Jody is there. Jody understands this process as good as anybody in this world. She is in the front bench as Justice Minister. She has the Prime Minister and the governing caucus behind her. How much more chance do we want?
Thank you. Robert Morales, Chief Negotiator for the Hulkaminum Treaty Group. We know that Section 35 now, through the courts, have said is about reconciliation. And they've also said that they view negotiation as the preferred way to achieve reconciliation. But they also said, and I've sort of talked about this a few times, is that they've said that good faith negotiation is the way that should proceed. But the courts have never really set out what they view as being good faith. And we got two former chief commissioners, and Dave, you've participated in the Yukon negotiation. What's your view of the difference between hard bargaining and good faith negotiation? Because the Crown will come to the table and say, well, they're just there and they're hard bargaining. It's just, but yet they put a lot of issues on the table. It's sort of that take it or leave it, in our view, approach. And how can we push back against that? Because that seems to really create a lot of impasses.
And I know that Miles will have lots of comments on that too. That good faith negotiations, I think, is what everybody enters this whole process expecting. And it's not very long when you have the situation like Catherine was describing yesterday and her frustrations about that the negotiations end up being, not only are they not good faith, but they're not even really negotiations about substantive matter. Another term that I think is one that we question about how the government how the governments live up to it, is the honor of the crown. It seems to me that you maintain the honor of the crown through good faith negotiations. But it does really, I guess, beg the question about how each party determines that. I'm sure that if you were to ask, well, no, I wouldn't even put it on the negotiators, the chief negotiators from the two parties that are sitting at the table, because I think in most instances, those individuals, as human beings, as individuals, they do approach the table with the intent of good faith negotiations. But I think that overall, as a government, the limitation on the mandates, it immediately removes the whole concept of good faith negotiations, because it comes in with such limitations. And the whole premise around the fact that these negotiations are with the Department of whatever it's called now, Indigenous Affairs, I guess. Yeah, we've gone back to DIA. So, you know, we've kind of gone all over the place with what this is called. But yeah, the Department of Indigenous Affairs, that negotiations are with them, but they're not. You know, I think good faith negotiations means that the negotiations are with the Government of Canada. And as a Treaty Commission, you know, I think that we've done a good job in the last few years, and the Commission continues to do so, in reminding the government about that and ensuring that it's that concept is not set aside, and that good faith negotiations includes all the negotiations, whether it's about fisheries or justice or parks or whatever, that they're done that way, and that they're done from the Government of Canada's point of view to protect the honor of the Crown.
That's a really important question. How do you ensure good faith negotiations in this, what is a political process? I mean, we did the first step in that. We laid out and defined a process through the BC Claims Task Force that was accepted by the Government of Canada, the Government of British Columbia, and each of the participating First Nations. That's appropriate. You got to decide what you're at the negotiating table for. You know, are you working toward building a duck, or are you working toward building an airplane? You got to be clear about what this treaty framework you're working to have effective negotiations. We were really clear in the BC Claims Task Force that it was about sorting out jurisdictions from ancient continuing nations with the Crown in right of Canada. Now, I was Chief Commissioner and observed intimately the negotiations as they unfolded. The first thing Canada and BC did, the first thing the Crown did, is they did a secret cost-sharing agreement between themselves that governed how they negotiated. This formula, which nobody ever officially sees, I hear a few people have seen it, they weren't supposed to, but have seen it, directed Canada and BC to split the costs of $100,000 per head, per capita, in each negotiation, and gave out land and government services on that formula. Now, is that good faith? After reading the BC Claims Task Force report? Absolutely not. But you have to have respectful relations between the parties to enforce that, and you got to have leverage. In terms of government-to-government power, this table is lopsided in the Crown's favor. You know, they have the money, they have the army, they have the enforce, they have the statutes. They have there's ways we can make it right, but one of the main things we depend on to enforce good faith is the courts. We could speed that up. I think Harry gave us a little insight into that, using a tribunal that's meant to guide a political negotiation like that with in the shadow of the courts. I think that would be really good. And the Treaty Commission had proposed that a few years ago, but the Crown didn't even pay any attention to it. So that's a really good question. I think we should keep our mind on it. We can keep bugging them, keep going after them, reminding them, going to courts occasionally. You know, Ian Binney's speaking tomorrow. Ian, I wouldn't want to write your speech for you, but tomorrow's an opportunity to Ian was on the Supreme Court of Canada bench, and I've heard those Supreme Court of Canada judges say repeatedly, the Crown, the governments must uphold the honor of the Crown. The courts have clarified First Nations rights and entitlement, and if they don't honor those, they're going to feel the whiplash of the courts. I don't think they've been whipped very hard. You know, the courts have done a great job in framing out what our rights and title and all that in a beginning way to enable a good faith negotiation to happen. I think the courts need to whip them a little harder. Ian, it'd be fascinating to hear your view on that tomorrow.
I just wanted to add two quick thoughts that I have. One is that I agree that there is a power imbalance at the table. So I think the parties should address that and work out a process internally amongst them as to how to ensure one side of the table, in this case being Canada, does not unnecessarily exert its authority against what the parties had agreed to. That they agreed to a good faith code, for example. And if any of the parties breach that, then they address a process as to how to rectify that. It could be a penalty for resource sharing. If Canada goes off, the resource sharing goes up by 5%, just using that as an example. Not to say that will happen. The second thought that I've got is that all options, in my humble opinion, are on the table or should be on the table. Everything from models of treaty making and every construct throughout Canada should be on the table, simply because another treaty preceded you in the province of BC should not dictate the extent of what is realized under that treaty. To me, that's not good faith. If you want to advance a model, a new concept that has not been articulated, or if you want to build on, my assumption has always been, perhaps naively, that we grow as a people in Canada, that we evolve. The concepts in the Yukon should be at least a starting point here, and that any agreements in BC should transcend all of those concepts that were embedded within the Yukon process. But that's not happening. There seems to be one size fits all approach, and that's the mandate that's been issued by clearly by Canada and apparently by BC. And I'm sorry, if you don't like that construct, then we'll move on to the next table. That, to me, is not good faith.
Okay, we've got a comment from Judge Slade.
Robert, you mentioned that courts have, say good faith. They use the phrase, but haven't really explained what it means. Courts answer questions that are put before them. And I think it unlikely that a court is going to establish a code of good faith, because good faith is, and the failure to act in good faith is hard to describe, hard to define, but you know it when you see it. So, for a court to pronounce on that, it has to be brought before them in a particular set of circumstances where the person bringing it says, this is not good faith bargaining. And then the court has something to grab a hold of. Of course, with deference to my friend Ian Binney here, of course, the Supreme Court of Canada decides questions all the time that aren't put before it, but
Going to to be an interesting panel tomorrow. Okay, I think we're moving to our last question.
Thank you. Good afternoon. Shanna Manson. I'm a technician with Lyakson First Nation Pahalikton. It's our hereditary chief here as well. The question I have is more from your experiences as negotiators in your communities. Right now, what we're having is a problem with British Columbia. The minister is on record as saying it's going to take 220 years to conclude negotiations in the province of British Columbia at this rate. And half the First Nations in the province aren't actively participating in this process, and they're signing off one-off agreements and sectorial agreements with the provincial government, pretty much shooting ourselves in the foot in terms of strategy. How do we have that meaningful tripartite negotiation when one of the parties is like the little kid whose parents said, sit at the table and finish your vegetables? They don't really want to be there. They're begrudgingly there because it's their duty, as was said, as a crown, that they have to be there to represent British Columbia. How do we get past we finally got the feds on side with Harper gone, and now we're dealing with the same attitude from British Columbia. How do we shift that?
I think that BC has not yet seen, and maybe has not yet really. I'm sure that they've thought about it, but they've not yet really processed that. In fact, we don't have the same situation now that we had when Stephen Harper was the Prime Minister. We had just the discussion that we had yesterday from a senior official opening the door. And I think that it's been a little bit easier for BC to be lax the way that they were when we did not, have a very strong party on the other side supporting this whole process. So, how do we get them back? I think that it's like what Dave said just a few minutes ago about it. Really, the treaty negotiations are with ourselves and the federal government, and BC, if they want to be involved, it's up to them to get back to the table. And I think that now that we have a Liberal government led by Prime Minister Trudeau with this very open commitment to having a different relationship, and we have a very different construct in that whole government, I think that it's very much going against this continued resistance that we've had from the province. So I suspect that we're going to see a little bit more action.
I just want to say that based upon my experience here in BC, I know that when we went to the table, my First Nation has Aboriginal title to about 5,000 square miles of land in BC. We got a treaty in the Yukon Territory, but we've retained title, so to speak, common law, in a common law form and fashion. But when we tried to work out an agreement with Canada and the BC Crown, the people that we were talking to at the table were basically the negotiators for BC. Canada was strangely silent. We tried to drag them into the discussion all the time, but it was being led by BC. And we had to remind them that the exclusive authority to make treaties in Canada is vested in the Crown and right of Canada. That, in fact, in 1899, Treaty 8 was made in BC, in the northeastern portion of BC, without the consent of BC. That was a treaty agreement that was imposed upon BC because of the unique relationship that the federal crown has for treaty making. And that was the law in 1899. That law, as far as I know, has not changed. And I recognize that there's issues about maintaining BC in a fashion that is respectful but not to where they can impede a good faith talks between the First Nations and the federal crown.
Shanna, that in the BC Claims Task Force 19 recommendations, that was the intended role of interim measures, what you're saying. If one of the parties to the, so the process begins by mutual recognition. Canada, BC, each participating First Nation states their intent to enter into treaty negotiations. So that's an act of recognition. The purpose of interim measures, which each of the three parties agreed to, was that when negotiations start, we have totally overlapping jurisdictions. So the intent was if a party, and this would be mostly First Nations, pointed out an area where jurisdiction was being imposed on them against their will, in a way that they didn't want to just turn the other cheek, that they didn't want to live with, that the other party would engage with them in an interim measures negotiation. And we started off really well on that. You know, we had protocols with Mike Harcourt's government. The first meetings of the interim measure protocol, the whole cabinet would be at the table with the summit task group, and we were working out legislative mechanisms to do this. And then they saw how, you know, this is difficult stuff. If you have a mine coming up and the First Nation says, no, we don't agree with this, so let's do an interim measure, and the interim measure was a measure of control over the project. BC had a heck of a time selling that to industry and local groups, so they abandoned it. So Premier Harcourt, after having this great start on interim measures, just started taking his existing Aboriginal Affairs programs and, you know, putting a few new clothes on them and some lipstick and calling them interim measures. They weren't interim measures. They were just existing programs, and that's been a weakness of this. And the only authority we've had to enforce the concept of interim measures is the courts. And you know, I think of our strategy with the Haida Nation in the old days when culturally modified trees, the courts recognized protection of them. And then BC interpreted it as, okay, here's a bark strip. Logging company, just cut above the bark strip. Take the rest of the tree, leave the bark strip. We went to court and said, no. Stage Act was the name of the case. We said the whole purpose of a CMT was the experience of the artist in an intact forest. You got to protect the whole thing, and the courts came with us. And there's been a whole series of them across the province that have been fairly effective in doing what you're saying, but we've just had to live by our wits in that. It should have been an interim measure negotiation to resolve that. We got to rely on the courts, and the courts have been effective but slow.
Okay, we're at 4 o'clock, everybody. It's been a very long day. Not seeing anybody jumping up and down. I'll do what my grandson says. Put your hand up if you have a question. Put your hand up if you want a speech from Miles. Joycelyn.
Thank you. Joycelyn Mitchell from Metlakatla. At our negotiating table, we've posed the question about the promises from the new government and their proposed changes and improvements to the EA process, to accepting the declaration. There's been many promises by this new government, and what we've been told at our treaty table is that they get their mandate from cabinet and they don't expect to see any changes. So how do we change, or how do we make sure that this opportunity is not going to be another opportunity that's going to slip by us? How do we make sure that the promises actually make it to us at the treaty table?
I think you have to make a list of what the promises are, characterize them based upon your understanding for changes to environmental assessment. And I think there is a need to get an agreement or even a protocol understanding with respect to the changes that are to be rationalized within the environmental assessment processes. And so historically, we know what happened under Harper. We know that a lot of the assessment processes have been truncated time-wise, the responsibilities undermined, and hence they make for very weak assessment processes for mega projects, be they LNG, oil and gas, etc. But I think that list, that understanding, has to result in some sort of an agreement that informs a mandate that is then issued by Canada to inform their team to advance that at your tables. And that's just my sense. And but that requires a lot of lobby work, and I think we're all up for the task.
Yeah, exactly. You know, the discussion that we started yesterday with Joe Wild, again, you know, I come back to that here's an opportunity where we could start to address that. Now, when the Prime Minister gave out his mandate letters to all the various agencies, that eventually will or has to have some impact in the mandates that are given, that are given at the table. I don't think we're going to see all of those immediately. I mean, these are 4-year mandates. They have a 4-year mandate, rather. And these are, I think it's just a matter of us continuing to ensure that this is dealt with, and that we are moving forward and continuing to put that at the forefront so that it doesn't get shuffled aside. But it was the, is it you, Miles, or somebody was talking this morning about the fact that there's the environmental regulations, like we've got the assessment process here in BC, and then you've got the federal assessment process. So yeah, I think with that we just need to keep on taking any opportunity that comes forward, like the opportunity that's available to us now, in helping to strengthen those mandates that are coming from the various levels of government. You're good? Okay.
Okay, any other questions? Oh, one.
Couldn't resist. Dave Sheppy from the Stala table. When we were talking about nationhood throughout the whole course of the forum, and we've seen lots of presentations on building governance, building constitutions, working towards development of nationhood among First Nations. And there was a specific piece I know we've been struggling with at our table, which is jurisdiction over children and families. And I just wanted to put that out there. Is that not a critical piece of nationhood, having authority over your own children and families? And as a starting point, shouldn't that be something that's established throughout all the tables if nationhood and building nationhood is going to be a product of treaty making?
As I was saying earlier, when you sit down and figure out what each nation, who they are, what they want to negotiate at the treaty table, and what's they can share or give away, I would have the view that jurisdiction over children and families, as BC and the feds have laid out, is one that has to be in our hands. Just look at what's happened in BC over the past few years. BC has tried like the best they can to look after Aboriginal children after all the horrific things that have happened to our families. They put, Ted Hughes' report put Mary Ellen Turpel in place to monitor it, so she's shone a bright light on what's going on in that area. BC has put in more and more money, they've trained their people, and they've failed miserably. They put this guy in recently, Plekas, because they're not willing to put more money into it. They got to find another solution. They have to admit that they've failed. And you know, First Nations, every nation, I think, should be going to the table and saying, we will maintain jurisdiction over our children and families. And, you know, in the last few years at home, being not involved in politics, I mean, family is something really crucial to every one of us. That is the most gut-wrenching issue going. But you know what? If we can't handle that jurisdiction, what can we? It's critical. And that's the test of a nation, is helping each other. I think that's one that it's crystal clear we have to resume that. And that's going to take having the resources to do it properly. But that's an issue each of you are going to have to make. I know where I stand on that, when we have to maintain that. Nobody else can do it.
I absolutely, totally, and with every part of my being agree with that, that nobody can look after our children the way that we can. And I would just throw the question back to the First Nations, that why are you even questioning, why are you even waiting? There are methods of gaining, like through processes that are available to us today, of gaining some measure of control. And I think that every First Nation in British Columbia should be taking advantage of that and gaining that back, yeah, it's through the provincial system, but it is a stepping stone toward your own total jurisdiction once you're at that point where you've got a treaty and this is one of the areas that you're going to be taken over. We've had responsibility for child and family services, and we being Ktunaxa, we've built that up probably over almost 30 years. And we started with just groups of parents getting together, being, you know, really upset about the way that we were being treated as families and the way our children were being treated, to the point now where we have total jurisdiction. And we are responsible for every single Indigenous child in our traditional territory. First and foremost, we're responsible for Ktunaxa, wherever the Ktunaxa child is. But then we also have jurisdiction for every other Indigenous child that lives within our territory. Those types of measures are available to us right now, and we should be taking advantage of that. We have to take advantage of it. And if and when we ever sign a treaty, the governing process that we've established for looking after child and family services will be then incorporated into the treaty. It's not something that we're going to wait until after effective date to become involved in.
In terms of the what we did as part of our agreement in the Yukon is that we've got exclusive powers over matters that are internal to us and over anything within the treaty, but we also have a paramount concurrent law over our citizens in the Yukon Territory, including over children and childcare, so that if a Champagne-Ajac child is in care somewhere other than within our territory in the Yukon, that child is still, the parents of that child are still responsible to follow the dictates of that Champagne-Ajac children's law. That law, to the extent of any conflict or inconsistency with the law of the Yukon Territory, is a paramount law to the extent of the conflict. Now, that model is out there. It's for you to consider. And I know that the Nisga'a have a comparable power within their treaty, but with respect to its applicability, I believe, to the 26,000 square clicks of territory that they may have. It doesn't apply throughout BC, but the comparable Paramount Concurrent Authority in the Yukon applies throughout the Yukon territory. So that's a possible model to use as well.
And I think it related to your question also. When you take over or maintain, like this, in this case, taking a jurisdiction back to yourself from one of the existing crowns, in this case, the province, you have to, realistically, you have to have the resources to implement it. That comes with it. And that has to be the tough part of the negotiation, and that has to be a negotiation, not the Indian Affairs discount. It's got to be the same level of funding as any kid, any child in society receives. These are serious issues, and that's what the treaty table has to ensure, has to enable.